This evening, we're especially pleased to have with us an extremely distinguished panel of judges. Presiding as Chief Justice is the Honorable Sandra Day O'Connor of the United States Supreme Court. Sitting with Chief Justice O'Connor this evening are the Honorable Ruth Bader Ginsburg from the United States Court of Appeals for the District of Columbia, and the Honorable John J. Gibbons of the United States Circuit Court for the Third Circuit. And now the contestants. For the petitioners, Peter Rogers and William French Smith. Oralists, Lloyd Randolph and Frederick Nelson. With them on the brief are Frederick Haber, Laura Besganek, Sharon Oxborough, and Michael Zachary. For the respondent, James Mendez. As oralists, Jim Garing and Edward DeAngelo. With them on the brief are Lawrence Studnicki, J.D. Stahl, Jody Jacosa, and Fairleigh Dalton.
Please hold all applause until all the contestants have spoken. There will be no photography during the argument, but there has been a 2-minute period which has been reserved for photographs, which will take place immediately after the justices have been seated. There will be a reception following the argument in which the judges and contestants will be present in the John Shipman Graham Room in Town Hall.
Thank you.
Oyez, oyez, oyez. The Honorable, the Supreme Court of the United States of America is now in session. All persons having business before this court shall come forward and give their attention, and they shall be heard. God bless these United States and this honorable court.
Mr. Randolph,
Yes, Your Honor.
you may proceed.
Your Honor, I think there has been a 2-minute picture-taking session reserved for this. With the court's permission, we would like not to foil the BSA's plans.
Very well, counsel. No, the plan, did they?
No, that was no.
Proceed, Mr. Randolph.
May it please the court, my name is Lloyd Randolph, and on behalf of the government, I will argue that the prisoner transfer treaty between the United States and Rossland is constitutional. I will also argue that the federal courts should not question the criminal proceedings of a foreign sovereign. My co-counsel, Frederick Nelson, will argue that the respondent in this case, Mr. Mendez, consented to his transfer to the United States voluntarily. Mr. Nelson will also argue that the simple presence of the Drug Enforcement Administration agent at Mr. Mendez's arrest and at some of his questioning does not implicate the United States in a joint venture. The United States is deeply concerned about the conditions under which convicted Americans are being held in prisons in certain foreign countries. It has done what it can to better their lot. As part of that effort, it has entered into treaties with 8 such countries which permit Americans convicted in those countries to be transferred to the United States to serve their sentences. One of those countries is Rossland. James Mendez was convicted under the laws of Rossland of possession of cocaine and conspiracy to distribute cocaine. He complains that the criminal procedures of Rossland were inadequate and that a Drug Enforcement Administration agent of the United States was present at his arrest and at some of his questioning. Mendez faced harsh conditions in Mexican jails and prisons, conditions similar to those faced by many Americans convicted and imprisoned abroad. The United States provided Mendez with a copy of the treaty and an attorney. Article 6 of that treaty explicitly states that persons transferred from Rossland to the United States cannot challenge their Rossland convictions in United States courts after their transfer. In his consent to transfer, Mendez agreed to that condition. A few months after arriving in the United States, Mendez petitioned for a writ of habeas corpus. He claimed that the treaty that rescued him from the bad conditions in Rossland's jails is unconstitutional. He also claims that his consent to transfer was involuntary. And lastly, he claims that at his arrest and that at some of his questioning, a DEA agent was present, and that agent's presence makes the United States responsible for the activities of Rossland authorities.
Mr. Randolph, I guess one of your arguments is that the question is a political question and the court can't decide it. Is that correct?
That is true, Your Honor.
Now, what are the political questions which the petitioner contends that this court can't decide? Certainly, the court can consider the constitutionality of a treaty, can't it?
Absolutely, Your Honor. The political question involved in this case is merely the procedures that were used by the Rossland authorities. The government has absolutely no quarrel with the court's authority to adjudge the constitutionality of the treaty. What the government does urge is even if the court does find the treaty unconstitutional, it should not look into that foreign sovereign's criminal proceedings. But, of course, first, as Your Honor rightly points out, the question of the constitutionality of the treaty must be looked into.
Mr. Randolph, since you pressed that point as the first argument in your brief, I would like to follow up on the question that you've been asked. And specifically, would any political question be presented if the same allegations were made by Mr. Mendez in contesting use of that Rossland conviction to count as one conviction for multiple offender statute purposes? Would any political question be presented?
No, Your Honor. The government doesn't believe that a political question would be presented in that instance. As Judge Friendly made clear in the Lanier decision, which is cited in the respondent's brief, the use of a foreign conviction in that instance would implicate the court that was sentencing the offender to an additional period of time in a violation of due process.
Well, using the Baker versus Carr factors, how is that different? What makes that not a political question and yet this is?
Because, Justice O'Connor, the court, using the multi-offender statute, takes away an additional chunk of the convict's liberty. Here, no additional liberty is taken away. The only choice that's presented is...
You're addressing the consequences, the questions, what the court would review. That
yes,
is,
Your Honor.
the
yes,
terms of the Mexican conviction
right, Your Honor.
or the Rossland conviction would be identical.
Right. In that
questions do not differ, but in one context you label them political, and in the other you do not, and I find that difficult to follow.
No, Your Honor, they are slightly different. The difference is that in our case, the United States merely permits Mr. Mendez to choose in what country he will be incarcerated. In the cases in which a foreign conviction is used to, in a multi-offender sentencing context, an additional liberty is deprived. The sentence is enhanced because of a foreign conviction, and that foreign conviction then becomes the basis for imposing an additional period of restraint on the...
Suppose Mendez had escaped and he made the same assertions in opposing extradition? Would the questions be political?
No, Your Honor, I don't think they would be. I think the responsibility of the United States would be fairly clear to extradite the person who had escaped, if indeed the United States does have an extradition treaty with Rossland, which is something that is not in the record, and as far as we know, the United States may and the United States may not.
Well, the United States may or may not return him even under this treaty, isn't that so? The treaty doesn't provide for return.
No, Your Honor, that is correct.
And that would be at least in the discretion of the Attorney General.
That is also correct, Your Honor. Mr. Nelson will cover the return provision in his discussion of the consent aspect of the implementing legislation.
Are you suggesting that in circumstances such as this case, if he had escaped from Rossland and made his way to the United States, a court considering a warrant for his extradition would not take into account the circumstances of his conviction?
Yes, Your Honor, I am suggesting that.
And in this case, specifically, the allegation which we must take as true, that his conviction resulted entirely from a coerced confession.
Yes, Your Honor, that is the allegation that has been made. Mr. Nelson, as I said before, will cover the question of whether or not the consent was voluntary.
Well, aside from the consent, because in the hypothetical of an escape, that wouldn't be involved, would it?
The question of voluntariness?
No, of the consent wouldn't be involved
true, Your Honor.
in the extradition case.
That's certainly true. I'm afraid I've lost the direction of Your Honor's question. It is, if he escaped...
And a court was considering an extradition warrant. Would it be foreclosed by any law from considering the involuntariness of his confession?
Your Honor, I don't think that the court would be permitted to look into that. Extradition cases do make plain that the Attorney General and the executive have the authority not to extradite someone if they think that the conditions that he would face abroad would be bad, and perhaps also if they think that he would be, if they think he would have been unfairly convicted. However, that is not the responsibility of the courts. That was made clear in both the Sindana case and the Galena case. The rule laid down is that that is the executive's responsibility under extradition treaties and not the courts. And I think that same precedent is useful here.
Even though the executive would be acting to enforce a conviction based on an involuntary confession?
That is right, Your Honor. That would be within the executive's discretion, and if the executive found that circumstances were sufficiently strong that it should not extradite the prisoner, then it shouldn't extradite him. That is not a question for the courts, however, when the responsibility of the United States is to extradite. All that the courts look into in that situation is whether or not there is an extradition treaty and whether or not the other country has brought forward enough evidence in a probable cause hearing to allow that person to be extradited. If the country does that, then the case must proceed. Going back to the question, however, of the constitutionality of this treaty, before the court does look into that, the court needs to be aware of the fact that Mendez challenges this treaty on its face. This is a core case because the treaty benefited precisely that group of people, in this instance, that the Congress and the executive sought to benefit. That is, an American convicted in a foreign country and imprisoned in bad conditions. If the court finds it necessary to strike down this treaty, then not only Americans suffering in prisons in Rossland, but also Americans suffering in prisons in Thailand, in Turkey, in Mexico, in Panama, in Peru, and in...
Mr. Randolph, are you telling us that an individual's rights may be sacrificed to the greatest good for the greatest number? Is that the thrust of your argument?
No, Justice Ginsburg, that's not what I'm suggesting. I think that the fact that all of those other Americans are involved does go to the political question issue of the urgency of and the unusual need for an unquestioning adherence to a political decision already made.
Is that the factor? Is that the Baker factor that you're singling out?
Yes,
since
Your Honor,
you listed all of them? But that's the one on which you place primary reliance?
No, Your Honor. 5 of the 6 Baker factors are present in this case. The fact that other Americans are imprisoned abroad does go to the 5th of those Baker factors, the one that I just enumerated. But as to the constitutionality, it is important to note that this is a challenge to the facial validity of the treaty. The government believes that this treaty is constitutional. It does believe that because Mendez never had a right to challenge his foreign conviction in the courts of the United States, and he didn't acquire such a right on transferring here. The consent provision of the treaty merely warned Mendez that he wouldn't gain that right, and by assenting to the condition, he indicated that he understood that. But even if the court does believe that upon arriving in the United States, Mendez received a right to challenge his incarceration, his waiver of the right to challenge his foreign conviction in United States courts prevents him from making that challenge here. This court's decision in the Jackson case makes that plain. In Jackson, of course, the court struck down that clause of the Federal Kidnapping Act that prevented people from being executed unless a jury recommended. The court said that the evil in that federal statute is not that it necessarily coerces guilty pleas and jury waivers, but that it needlessly encourages them. This case is just the opposite, because the consent condition in this treaty was absolutely necessary. The legislative history of the treaty makes plain that Rossland would never have entered into this treaty unless the United States was willing to protect Rossland's sovereignty by not allowing Americans convicted in Rossland and transferred to the United States to challenge their convictions in American courts.
Mr. Randolph, how can that contention be credible when you acknowledged not too long ago that the Attorney General could decline to repatriate?
No, Your Honor, the Attorney General in this situation does not have authority to decline to repatriate. If I said that a minute ago, I'm sorry. I thought the question was, in an extradition context, the executive can decline to repatriate. In this instance, the return provision, 4114, mandates repatriation if the government of Mexico requests it, and that provision was necessary.
Are you referring to Section 4114?
I believe that that is the relevant section, Your Honor.
It says may.
However, the Attorney General also has a responsibility under the treaty, and I believe the article is 4, Part 9, to, yes, Your Honor, that is correct, has a responsibility under the treaty to give effect to the, give legal effect to the sentences pronounced. The purpose of the return provision was to do just that. Mr. Nelson will go into that in greater detail. And I think that that I would be best to leave that to him. He's an expert in that. Going back to the Jackson analysis, Your Honors, the consent condition here is absolutely necessary because of the insistence of Rossland that the condition be in there. It also meets the second wing.
Well, of course, here you have a defendant who challenges the validity of his consent. So,
yes, Your Honor. The consent, well, actually, Your Honor makes an interesting and good point, and that is that the consent condition and the conditions under which the prisoner is held need to be looked at separately. The question in the consent aspect of the consent condition constitutional analysis is whether or not the choice that the treaty presents should be taken away from the individual as unconstitutional. Once that determination is made, then the court should analyze whether or not the consent was given voluntarily. And of course, if either problem, either the consent condition being unconstitutional or the conditions, the circumstances.
wouldn't we normally approach the case by deciding the consent validity first? We could avoid a constitutional issue, possibly.
Well, Your Honor, the constitutional issue here is inescapable because the court below has held this treaty unconstitutional, and that's the principal thing that the government seeks to have overturned. The respondent in his brief plays a little shell game between these two questions. When you first think he's going to focus in on the issue of whether or not the consent condition is constitutional, he then shifts over to the issue of the conditions, the circumstances, I should say, under which he was confined. The court needs to look at those two questions separately. The first question being whether or not the choice of being allowed to come to the United States and escape those conditions should be taken away from the individual because of the because the consent, the requirement, that is the condition on the benefit, is unconstitutional. The government asserts that it's not unconstitutional here because the consent condition was necessary. It is also not unconstitutional because this was the least restrictive alternative for attaining the benefit that was sought. That is so for two reasons. One is the restriction on the right to challenge was limited to the narrow issue of whether or not, or restricted to the narrow issue of being unable to challenge his foreign conviction. The other reason that it was the least restrictive alternative is that immediately upon arriving in the United States, Mendez became eligible to be considered for parole.
With respect to that, I take it Mr. Mendez has been eligible for parole, or indeed is on parole, since he has served more than 1/3 of his sentence. Are you suggesting that as a factor that might make this case moot? What do you do with the current eligibility of Mr. Mendez for parole?
Well, the government suggests, Your Honor, that his eligibility for parole demonstrates that the government, or that the United States, in negotiating this treaty and in enacting its implementing legislation, has chosen the least restrictive alternative to the conditions on the benefit. The question of whether or not he is now on parole or might be eligible for parole certainly does not make this case moot, because even if he is on parole, he is still under certain restrictions, and therefore...
Are you arguing that he has to exhaust the possibility of being released on parole before he challenges his incarceration?
No, Your Honor. I'm only speaking to the issue of whether or not the condition on the benefit, that is being allowed to come to the United States, was as narrowly drawn as possible. In the Jackson case, the court indicated that the condition, that is waiver of jury trial or pleading guilty, was not as narrowly drawn as it might be. And in this case, we believe that that part of the Jackson analysis has been met.
On the parole question, is there anything in the treaty or the legislation to prevent the government from granting parole to all people whose convictions were obtained in a questionable manner?
No, Your Honor, there is none.
Is there anything to prevent unconditional release?
I'm not clear on Your Honor's question.
I asked you if the government might consider this case moot in view of eligibility for parole. Right. Your response was no, the government does not consider this a moot case, that you were merely pointing to parole as the least restrictive condition, that, right, that the government has pursued this in the way most favorable to the person who's transferred.
Right.
Now, suppose Mr. Mendez could be, at this point, unconditionally released.
No, Your Honor, I don't think he could be unconditionally released. He could be paroled. He would, however, still have that restraint on his liberty.
Mr. Randolph, if he could be paroled and he were to be picked up for a parole violation, wouldn't an American court be in the same position as the Lanier Court of enforcing that condition of parole for a sentence obtained in violation of the privilege against self-incrimination?
No, Your Honor. I'm not exactly clear on the last part of Your Honor's question.
Well, by hypothesis in this case, his conviction was obtained with a coerced confession. If he was picked up for a parole violation, wouldn't we be enforcing a conviction based on a coerced confession?
No, Your Honor, he would not be, because no additional restraint would be imposed. If he is returned to prison after that parole violation, he is returned to the same prison and under the same circumstances that he might have been if he had never been paroled, and only the government's bounty caused him to be paroled. If the government chose not to exercise that bounty, he would still be in that same prison.
And the bounty, you say, does not include unconditional release, even if the Bureau of Prisons should recommend that he be deemed, after service of 1/3 of his sentence, to be totally released, not paroled.
No, Your Honor, the treaty specifies that the sentence must be carried out
in accordance with the law of the receiving state.
Yes,
Isn't that part of the law of the receiving state, that there is that possibility of unconditional release? Or don't you know?
Well, I really don't know. Again, that is a question that's more in Mr. Nelson's bailiwick. And seeing that my time is up, I think perhaps I should.
Thank you, counsel, and Mr. Nelson. Mr. Nelson, I hope you will discuss, among other things, why it is that the district court should not be required to hold a hearing to determine the validity of the exercise of the waiver or consent.
Yes, Your Honor. If you like, I'll move to that point right now. Mr. Mendez bases his argument that his consent was invalid, as you suggest, on the claim that a verification of consent hearing was not held under Section 4108 of the hearing of the implementing legislation. But that
and also that it was coerced and the other allegations that he makes.
I'm sorry, I was referring to respondent's brief rather than to his petition. He does not in his brief, in his petition, argue that the government violated the law and failed to hold that 4108 hearing. And what I'd like to do is talk for a little bit about why we should go under the assumption that a magistrate did question Mr. Mendez and ensure that he understood what he was doing and that he voluntarily consented to come.
Well, I think my concern is why the district court should not be required to hold a hearing on the voluntariness of the consent issue.
We're quite confident, Your Honor, that if such a hearing were to be held, the district court would come to the same conclusion that we reach. It's our argument now.
But isn't that the function of the district court as a trier of fact to make that determination? Why should he be precluded from having that hearing in the district court?
Because, Your Honor, I don't believe that such a hearing, and the government does not believe that such a hearing is necessary given the record of this case.
Didn't such a hearing occur? The district court held a hearing limited to the voluntariness of appellant's consent to transfer.
That's correct.
That is precisely the issue on which the district court did hold a hearing.
But as the Chief Justice has indicated, the district court's conclusion was that while he thought that consent was voluntary, he didn't see that he had a need to make that holding. I think that was the point to which the Chief Justice was referring.
Right.
It's the government's contention here tonight that the record on its face shows as a matter of law that Mr. Mendez's consent was voluntary, and so there is no need to hold such a hearing. As I say, however, the government...
to make a finding or to repeat a hearing that's already been held?
To make a finding, and I suppose the district court, if the case were sent back to him, the district court judge could
open it up for additional...
could take whatever steps he liked.
Mr. Nelson, don't the findings that he made in his findings of fact 11 through 16 establish as a matter of law that the consent was not voluntary?
No, I don't think so at all, Your Honor. What happens when under the verification of consent hearing is that Mr. Mendez is brought before a magistrate, a United States magistrate or the rough equivalent thereof, and is asked specifically if he understands the language of the treaty, if he understands the language of the consent form, and if he does indeed want to come to the United States. Mr. Mendez made a reasoned choice to return to the United States, to leave Rossland and to come over here. The conditions that he faced in Rossland were indeed very, very harsh, but this court, in examining, for example, the guilty plea cases, has held that a defendant facing grim alternatives does not necessarily make an involuntary choice. For example...
Well, suppose that the district court, having made the findings 11 through 16, had then made the ultimate finding that under that totality of circumstances, this consent was involuntary. Could we say that such a conclusion was clearly erroneous?
I think if the district court were looking just to the circumstances and not specifically to whether or not the magistrate that concluded that Mr. Mendez's consent was voluntary was correct or not.
Well, now,
yes,
we don't know on this record that the magistrate did so conclude.
It's the government's contention that we can safely assume as a matter of law that the magistrate did so conclude for a number of reasons. First of all, Mr. Mendez never alleges in his petition that the magistrate did not find that the consent was invalid, and the burden of proof is on Mr. Mendez to allege that fact. Secondly, there's a strong presumption that the government obeys the law and that they would not have transferred Mr. Mendez under the statute had his consent been involuntarily obtained or had the magistrate ruled that the consent was involuntary.
It is clear, is it not, that even if the magistrate makes a voluntariness finding, the district court can review that finding?
Certainly, Your Honor, as with any other finding of that sort. That's correct. But Mr. Mendez never even asked the district court, as far as we know. It's not in the record that he asked the district court to review that finding of the magistrate.
He did allege that the consent was invalid, didn't he?
That's correct, and he argues one thing in his petition and switches in his brief. I was referring to his argument made in the brief that the verification of consent hearing was not held. That's what he's now basing his contention upon, and that point was never brought before the district court in the petition. But Your Honor's point is well taken. He did make that allegation in his petition.
Mr. Nelson, who has the burden of proving that Mendez was given the procedural rights guaranteed him by the legislation?
Since the record is not silent on that point, Your Honor, since the government did include in its evidence before the district court the verification of consent form and did make in its answer an allegation that a statement that the laws were complied with, the burden of proof is on Mr. Mendez. The record shows no traverse to that answer to the habeas corpus petition, nor does it show any allegation that 4108 was not held.
Why should the burden be on the petitioner in those circumstances when the events took place in a foreign country and he's in jail in the United States and only the United States can get the information?
Get what sort of information?
The information about whether or not the magistrate made the necessary finding and conducted the necessary hearing.
Well, certainly, Your Honor, I think that information would be within Mr. Mendez's knowledge. Either he went before the magistrate or he didn't. The law requires specifically, 1408 requires that Mr. Mendez be brought before a magistrate and that the magistrate quiz him, basically, on voluntariness. And Mr. Mendez had never claimed in the petition that did not happen. As a matter of fact, the appeals court below, in saying that Mr. Mendez was brought back to this country under the terms of the treaty, cited specifically to 4108 the verification of consent provision.
We don't know where they got that from either. All we can say is that the record is totally silent on the verification officer point. It was not alleged specifically in the habeas corpus petition. The government responded generally, we complied with the treaty and all relevant United States laws.
I don't think the record is totally silent, Your Honor, because the verification of consent form itself alludes to, says that it was signed in the presence of a verifying officer. I'd submit with all respect that the record does give that indication that the verifying officer was present. Now, the purpose of that verification hearing is, as I say, to ensure that consent is voluntary and that Mr. Mendez knew and understood what the conditions on his transfer were. As Justice Gibbons mentioned, his petition states that the conditions of confinement surrounding Mr. Mendez were such as to make the consent involuntary. And I believe that allegation is wrong not only for a legal reason, but for that I gave to Justice Gibbons earlier, looking at this court's findings in the guilty plea cases, where, for example, in Brady, the court said that a defendant who had a choice between going to trial and then perhaps on to the death penalty or waiving his Fifth Amendment rights and pleading guilty and escaping the death penalty, that defendant was able to assess the situation, see what his alternatives were, and come to a voluntary choice. The same is the case here with Mr. Mendez. But more than that, there's a practical reason that the wrong legal standard adopted by the court below should be overturned. And I think that's a point that Mr. Randolph stressed early on. The fact of the matter is that if we only bring back to this country prisoners who are held in conditions of confinement acceptable to the United States, we're leaving behind those prisoners who need these transfer treaties the most, those prisoners who are in squalid conditions and whose only hope of returning to the United States is to be able to voluntarily reach a decision that they do indeed want to come back.
So that the more coercive the circumstances are, the more voluntary should we consider his consent to be.
Not that you should consider it, Your Honor, although perhaps the more voluntary would his consent in fact be.
The more you torture him, the more voluntary his consent is.
His consent to leave, I would think not as a...
We're not talking about his consent to leave, are we? We're talking about his consent to waive the opportunity to raise a question of the coerced confession.
To transfer to the United States under the conditions of the treaty and the implementing legislation that laid down. I'd like to make clear that my last answer was not a legal point. I think the same legal standard of voluntariness would apply if the magistrate who would question the person you're hypothesizing would, after questioning him, determine that he understood what was going on, understood the choices facing him, and did in fact want to return as conditioned to the United States, then I think that the magistrate could make a finding that he was returning voluntarily, Your Honor.
Mr. Nelson, in several places in your brief, you and your co-counsel stressed the fact that this prisoner had no vested right. would your analysis of the problem be different if there were some vested right that was being affected by this so-called waiver?
Different in part, Your Honor, in that those were really alternative arguments. The argument that Mr. Randolph was stressing in oral argument tonight was that even if there were a vested right that were waived under the conditions here, that waiver could still be considered constitutional because it was a necessary condition placed by Rossland on the treaty.
Doesn't the United States recognize an international law of human relations, of human rights?
Yes, it does.
And does the use of a coerced confession to support a conviction violate the customary international law of human rights?
Well, our argument here tonight, Your Honor, yes, I believe it does. Our argument here tonight is that the courts of the United States, as a matter of practice, do not look into the circumstances surrounding conviction in a foreign country, and that's
For what purpose? You've already conceded that in the multiple offender context, the court would, and that at least the executive might in an extradition context.
I think very well the executive might in an extradition context. I think as to the multi-offender cases, when we're referring to courts of the United States examining the proceedings in other countries, we were really looking into what our own courts are doing. They were really examining whether or not the New York State, I think, is the multi-offender statute to which you're referring.
But isn't it true, as a general matter, we don't enforce foreign penal statutes or judgments?
No, it depends, I suppose, on your meaning of the word enforce.
We don't implement them. We don't give them effect.
Criminal penalties you're talking about? Well, there have been a number of cases arising under treaties similar to this, in which we have done precisely that, Your Honor. Pfeiffer and Mitchell and Rosado are just a few examples, or are 3 out of the 5 examples, I believe.
Isn't there a general rule, though, that we don't enforce foreign country penal judgment?
Well, generally there would be no
for
need
example,
for us to...
collect a penal fine here?
We do enforce them in extradition contexts in terms of sending the people back.
So there is no general rule that we enforce them. If we must find a general rule, it probably runs the other way.
Well, I think generally there's no reason for us to enforce them because the United States is generally concerned with whether it or not its laws have been violated. Here, however, there's an overbearing reason to carry on the sentencing, and of course the person can be immediately released upon parole if the board makes that determination. Here the United States entered into a treaty designed to bring back to the United States people who were languishing in the harsh conditions that Justice Gibbons was alluding to moments earlier. I'd like to move, if I may, to the question of joint venture. The petitioner, Mr. Mendez, the respondent rather, Mr. Mendez in this case, states that one reason that even if his consent is found to have been valid, his petition for habeas corpus should still be granted is the presence of a drug administration enforcement official.
On that branch of your argument, I believe Mr. Mendez has said, I've stated all that I can. At least I should be permitted to discover. Why would you cut off the opportunity to discover the precise nature of that DE agent's participation?
Well, Mr. Mendez alluded in his brief, I think, and adopted the standards set out by this court in the Harris case, saying that specific allegations are needed if the courts are to examine such areas. And here, all that Mr. Mendez alleged in his petition for habeas corpus was the mere presence of a DEA agent at his arrest and at a few of his questioning sessions. He tells us specifically that the DEA agent never questioned him, and there's no reason for us to believe, no reason set out in the record to believe, that the DEA agent participated in any way in the investigation, in the interrogation, or in the prosecution of Mr. Mendez. And he has to give us some sort of allegation in in his petition.
How can he? He was not party to the conversations between the Rossland officials and the DEA agent.
But if he has any reason to suspect that the supposed DEA agent to whom he alluded in his petition was doing anything wrong, he should have, as the Pfeiffer court said, set out those allegations in his petition. So
Why
that we would
isn't it
know what
reason to suspect that the agent remained on the scene, that is, with the Rossland officials, after a United States statute directed him to leave, to not be present?
First of all, Your Honor, I don't believe that that's been established as a matter of fact. The timing factor to which we referred to in our brief bears on that. But secondly, and much more importantly, I think, there's no indication at all that even had the DEA agent violated the 1978 amendment to the Mansfield Amendment, there's no indication at all that that would constitute a joint venture or be any grounds upon which to base a habeas corpus
What's
petition.
the remedy for a violation of the Mansfield Amendment?
That has not ever been directly determined by a court, Your Honor, because so few of these cases have been brought under the Mansfield Amendment. Generally, it's to exclude evidence, the fruit of the poison tree. Of course, that would not be applicable in this case. But the government does not deny that Mr. Mendez may choose to act against the government in other ways. All that we're saying here is that Congress, in the legislative history, never gave any reason to suppose that it intended violation of the Mansfield Amendment to signal a joint venture. Generally, a joint venture involves much more active participation on the part of the United States agents than was present here. For example, the courts did not find any violation did not find any joint venture in Pfeiffer, where the DEA agent not only was present but also revealed a gun rather threateningly. In conclusion, I'd argue that because the treaty is constitutional and because Mr. Mendez gave a valid consent, he did not allege that no verification of consent hearing was held, there's a presumption that the government obeys the law, and there is the consent form and the evidence of the court below. Because those facts are true, the government would ask that this court uphold the treaty and thereby allow the United States to continue repatriating citizens of the United States who are languishing in very severe conditions abroad. Thank you very much.
For the respondent, Mr. Gehring.
It has already been pointed out this evening that Mr. Mendez has been transferred to this country as a result of a Rossland conviction based on one piece of evidence, a confession extracted under threat of torture. Because of the treaty which we're discussing this evening, Mr. Mendez has spent more than 2 years in an American prison and will either remain behind bars or under the restrictions of parole until the end of this decade. He therefore brings 3 independent bases for habeas relief. His first 2 claims, which I will discuss, are that his transfer was invalid and that American Drug Enforcement Administration officials acted in joint participation with Rossland officials in violating Mr. Mendez's constitutional rights. The third claim, which Mr. D'Angelo will discuss, is that Mr. Mendez cannot be held in an American penitentiary on the basis of this fundamentally unfair conviction. Mr. D'Angelo will also address the government's assertion that the political question doctrine somehow bars inquiry into this third claim. Mr. Mendez's first claim is that he did not knowingly and voluntarily consent to transfer to this country. The U.S. officials who orchestrated Mr. Mendez's transfer not only denied him the procedural protections which Congress explicitly intended to provide him, but the result was, as the Ames Circuit Court of Appeals found, Mr. Mendez's transfer was, in fact, not voluntary.
How was it harmful to him?
Excuse me, Your Honor?
How was it, what detriment did he suffer? What disadvantage did he suffer as a result of the transfer?
The disadvantage, Your Honor, is that he didn't fully know and understand the conditions that the United States now seeks to place upon
Suppose
him.
there had been a verifying officer there who agreed with you. Mr. Mendez, under these horrible conditions, could not possibly give his consent. Therefore, what would follow? What should the verifying officer do under those circumstances?
Your Honor, if the verifying officer had actually been there and had questioned Mr. Mendez and talked to him about the transfer, Mr. Mendez surely would have transferred in any event, but he would have understood the conditions which Congress intended him to understand, namely that he cannot challenge his conviction once he comes to this country. Congress understood that there were
In other words, if he had been fully informed, he would have made the very same choice.
Yes, Your Honor.
So he has suffered no adverse consequence as a result of what you say is a lack of full information.
He has suffered no adverse consequence, Your Honor, in that he's in the same prison today that he would have been otherwise. However, what Congress explicitly intended to do in
Well,
the
he's not
statute
in the same prison, is he? He's in the United States instead of in Rossland.
That is correct, Your Honor. He would have transferred even if he had been provided with a magistrate. The importance of the discussion between the magistrate and the prisoner is that it would have informed Mr. Mendez that once he was in an American prison, even if he was innocent, the government would seek to keep him from obtaining habeas corpus relief.
How has he been harmed? That's the question you haven't answered yet, that Justice Ginsburg.
In that now the government seeks to place a restriction which the government never intended to take away unless a prisoner knew and fully understood that condition. In other words, if Mr. Mendez had just been dragged out of Rossland by the Marines, he would be in a better position today than he would be in a Rossland prison. But Congress didn't intend that type of a scenario to happen. Congress did not intend to incarcerate innocent people in American jails.
But if we're stressing Congress's intent, wasn't it Congress's intent also that if the consent was invalid because it wasn't fully informed, the solution is to send the man back to Rossland so then he may exercise a fully informed consent?
That is very true, Your Honor. This court should not countenance the government's argument or the statutory scheme here which would return him to Rossland, because to do so would both punish Mr. Mendez for challenging the validity of his transfer, for challenging the fact that there was no magistrate in this case, and secondly, it would subject him to cruel and unusual punishment. The Ames Circuit Court of Appeals found that the conditions which Mr. Mendez faced in Rossland, if they existed in a prison here, would be cruel and unusual. This court has never...
So you're then suggesting the less he knows in Rossland, the better off he is when he gets back to the United States. Because if he knows everything in Rossland, he can't challenge, but if he doesn't know very much, then he can. Or are you saying that whether he knew or not, whether he knew everything, whether there had been a verifying officer, he could still, when he gets back to the United States and is incarcerated here, challenge that incarceration because the United States is holding him on the basis of a coerced confession?
Your Honor, the reason that it's important that he didn't know, and the reason it's unfortunate in these circumstances, is that it leads the court, if they find the transfer voluntary and knowing, if this court decides that there was a magistrate and that he actually knew and understood, then the constitutionality of the treaty the issue of the constitutionality of the treaty will have to be reached. Congress did intend to return prisoners, but I do not believe it's fair to assume that Congress intended to have a constitutional issue about the validity of incarcerating an innocent man in an American jail raised in front of this court if that prisoner didn't know and understand the very condition which is at issue here tonight, which is whether or not he can challenge that foreign conviction. And Congress stated that if that prisoner doesn't know, he must be released by the United States government. And at that point, the foreign government can ask for his return and the Attorney General might send him back. My argument is that if indeed Mr. Mendez's transfer was invalid, he must be released by this court. At that point, the foreign government could ask for his return, but he should not be returned because to do so would constitute cruel and unusual punishment. It would be sending back to conditions in which Mr. Mendez had to pay for his jail cell. He had to pay for his food, for his lighting, for his heat, for his toilet facilities. And even then he wasn't provided with even minimum amounts. The jail officials there extorted large amounts of money out of Mr. Mendez. And even then they beat him when he didn't pay. He was dragged from his cell and beaten with sticks and clubs and fists by those prison officials. Now the government says that even if the statute was violated, even if we didn't send a magistrate to Rossland, even if his consent was not knowing and voluntary, the only result is to send him back to Rossland. However, this court should not countenance that argument because it would subject an American citizen to the type of conditions which this court has never subjected an American citizen to before. The reason why the magistrate's inquiry is important is that Congress recognized in enacting Section 4108 that the personal inquiry between the magistrate and the prisoner was the one piece of evidence, was the one factor in the coercive conditions in those Rossland jails which would actually bear on whether the prisoner actually knew and understood the conditions of his transfer.
In view of your emphasis on the importance of a verifying officer who, by the way, may but need not necessarily be a magistrate, is that correct?
Yes, Your Honor. The judicial appointed under the statute.
What the district court had before it is an affidavit by Mendez saying that he was duly sworn by a verifying officer. His habeas corpus petition never says specifically that there was no verifying officer.
Your Honor, your question raises two very important points. The first point with respect to the consent form. Mr. Mendez did sign it saying, I, in front of a verifying officer, signed this consent form. However, in other prisoner transfer cases which have arisen, there is a second part to that transfer form, which is the part signed by the magistrate, a completely separate part of the form in which the magistrate says, I carried out this questioning of the prisoner as required by law, and I find it to be voluntary and knowing. That part is missing. The second point is that even though
Mendez hasn't said that it didn't occur, has he?
Excuse me, Your Honor?
Mendez hasn't said that it didn't occur, that the magistrate was not there and he was not asked the questions.
Yes, Your Honor, that is the second point. In all of the other cases which the government has litigated on the prisoner transfer treaties, prisoners have alleged, just as Mr. Mendez did in his petition, a lack of voluntariness and a lack of knowingness. And the government at that point automatically placed into evidence the transcript between the magistrate and the prisoner, the transcript of that dialogue. It's the one piece of evidence, much as in the Federal Rule of Criminal Procedure 11 cases, in which once there's an allegation that it's not voluntary and knowing, the government automatically produces that transcript. And under this statute, the Attorney General is required to keep a copy of that transcript. And it's very clear that if a challenge that Congress considered that if a challenge arose, the prisoner was supposed to present that piece of evidence.
But presumably the respondent himself knows whether that occurred or didn't occur, whether the hearing before the magistrate occurred or not.
Yes, Your Honor, that is correct, and there is no allegation in the habeas petition about that. Mr. Mendez's petition simply indicates a lack of voluntariness and knowingness. But that is enough under both the government's own practice under this type of this prisoner transfer treaty and under the analogy to the plea bargaining cases. In addition, it's very
Apparently, it wasn't pressed before the district court either, because the district court assumed there were two factors involved in the voluntariness. One, the nature of the penal facilities in Rossland, and two, the advice of counsel.
Yes, Your Honor. The district court did catalog the evidence.
Not a word about verifying officer.
That is true, Your Honor. The important point, especially with respect to the district court's finding about the attorney, is that if Mr. Mendez's attorney, Mr. Sloan, told him he could challenge his foreign conviction. Now, Congress, first of all...
He didn't tell him he could challenge his foreign conviction. That's not quite what he said. He said it was his opinion and the opinion of other legal experts.
Yes, Your Honor.
He didn't say, as a matter of fact, a court has held, or the Supreme Court has held that.
That's quite
Gave
true.
an opinion.
That's quite true, Your Honor. And as the district court went on to conclude, Mr. Mendez believed that representation, that he would be allowed to challenge his foreign conviction. The only representative which Mr. Mendez had to explain the treaty to him in Rossland was this attorney. I might first point out that Congress considered allowing the local embassies to appoint attorneys, and it rejected that scenario because of an inherent conflict of interest. And Congress also recognized that if a prisoner alleged conflict of interest, it would be almost impossible to prove. That's why Congress, first of all, wanted the magistrate to appoint the attorney, and that didn't happen in this case. But even more importantly, if there's only one person providing advice, if it's an attorney sent by a United States embassy, then the person is more likely to accept that advice, to, as Mr. Mendez did, believe that he could challenge the foreign conviction.
Well, wouldn't you still be arguing that the consent was involuntary even if his lawyer hadn't been selected by the State Department?
Yes, Your Honor. The point is that especially when the attorney is appointed by the State Department, especially when there's what Congress has considered to be a conflict of interest, there's a duty on the government. It's especially important to have a magistrate down there. The magistrate isn't just required to ask questions. He's required to ask certain types of questions. Specifically under Section 4108, the magistrate must inquire into whether there have been any inducements or improper promises to the person. And in a situation like this, it was incumbent upon the magistrate to find out whether an attorney or some third person or some member of Mr. Mendez's party family told him that once he came to the United States, he could challenge the conviction. I think it's very...
Mr. Goring, assuming all of this and assuming that we could conclude, as did the Court of Appeals, that the consent to transfer was not voluntary, we still have this statutory provision about return. Now, we would still have to decide a constitutional issue, wouldn't we?
This court could either interpret the statute, Your Honor, as only allowing return if there were a probable cause inquiry, or it could simply refuse to give effect to that return. Yes.
What in the statute suggests that interpretation?
There's nothing in the wording of the statute, Your Honor. There is a provision in the statute which requires it's in the discretion of the Attorney General as to whether or not the person should be returned. But in the legislative history, there was some discussion of whether or not people should be returned and what intent Congress was intending to provide there. And this
what about Section 4114B?
The section that refers to the Attorney General who may file a complaint to rearrest the person?
Yes.
Yes, Your Honor. That could be.
Doesn't 1441B suggest further judicial inquiry of some kind?
Yes, Your Honor. The point we're trying to make here is that Mr. Mendez, given the particular facts of this case, this court ought to interpret that statute as requiring some sort of inquiry into the probable cause of Mr. Mendez's guilt.
Would 1441B, by its terms, operate in any case other than a case in which the court found that the consent to transfer was involuntary?
No, Your Honor. The only time in which Section 4114 operates is with respect to the transfer, is the validity of the transfer. It does not operate with respect to joint participation or the constitutional issue.
What is the purpose of the judicial proceeding mandated by Section 4114B if some court has already decided that the consent to transfer was involuntary and the issue now is solely shall the prisoner be returned?
The importance of the judicial inquiry, Your Honor, is, first of all, this country should not send prisoners abroad, should not send American citizens abroad when there is no reason to believe that they are guilty, when there's no, when the foreign conviction doesn't constitute a probable cause to believe in guilt. And that's how the statute should be interpreted.
Do you read Section 4114B then as a congressional directive that before anybody is returned, there shall be a judicial inquiry into the underlying conviction?
Yes, Your Honor. I think the legislative history can be read that way in light of the statute. However, my argument is even if Congress intended to return the prisoners, then this court should, as a constitutional matter, rule that Mr. Mendez cannot be returned to Rossland if there is a type of conviction there which doesn't even constitute probable cause that he is guilty. In addition, the cruel and unusual punishment which the Ames Court of Appeals found provides an independent reason. This court does not have to reach the probable cause issue if it rules that American citizens cannot be sent abroad to conditions that are cruel and unusual. So that provides the first rationale for decision in this case, and the probable cause issue need not be reached. Finally, it punishes Mr. Mendez for asserting his rights under this statute to send him back to Rossland, because he has no incentive to bring an action if the only response of the government and if the only response of the American judiciary, such as the federal district court's response was in this case, that he only gets sent back to Rossland, even if the United States law was violated by United States officials who orchestrated his transfer. The second basis for habeas corpus relief in this case arises from the fact...
Before you go on to that, can we agree that you're at least one of the three legs on which you now stand to knock out this consent? The one about the lawyer's bad advice, you call it bad advice, you call it misinformation, but that is exactly what you say this court should hold, that very advice. You say your argument is that it is good advice, that it is correct information, not misinformation. I'm very puzzled by that.
That's very true, Your Honor, and Mr. D'Angelo will point out why the constitutional issue must be reached if the transfer is invalid. The point is not whether Mr. Sloan's advice was bad advice or good advice, but considering the circumstances, someone should have sat him down in that foreign prison and explained to him that he wouldn't be able to challenge his conviction once he came to this country, that America would fight him if indeed he tried to make that challenge, that they would fight him all the way to the Supreme Court. No one told him that. He was sitting in a foreign prison, and I think it's very easy to understand how an American sitting in a foreign prison where he's been treated unfairly could be told that, well, if you think you're innocent and you get to the United States, you'll be freed by the American judicial system. But nobody told him that because the magistrate did not.
Paragraph 16 of the petition for habeas corpus. Mendez does not allege that he was unaware of the fact. Quite the contrary. He reports what the treaty states, that a prisoner cannot challenge the validity of his Rossland conviction. Petitioner was so informed on the consent form. However, the attorney advised him that in his opinion, the preclusion of access to the courts was unconstitutional. That statement, preclusion of access was unconstitutional, says two things. Yes, the treaty says you may not have access. Two, in my opinion, it is unconstitutional. How can you then claim he didn't know that the treaty said he couldn't contest the Rossland conviction?
Your Honor, the question is not whether he had simply been informed of the fact, but whether he truly understood that fact, and then whether he voluntarily consented. In this case, as the district court went on to indicate in its finding of facts, Mr. Mendez believed that it was unconstitutional. Now, I'm not sure how a non-lawyer views a statement that it's unconstitutional, but I think it's very clear in this case that what Mr. Mendez thought is that once he came to this country, he could challenge under habeas his right to be incarcerated, and that is why very quickly, once he arrived in this country, he filed a habeas corpus petition. He thought it would lead to his release, and he believed that advice by the attorney in this case.
But he would have come here even if he didn't.
That is quite true, Your Honor. The second basis for habeas corpus relief in this case arises from the fact that American Drug Enforcement Administration officials acted in joint participation with Rossland officials. Now, there's been no evidentiary hearing on this issue, and there's been no discovery. Mr. Mendez asks for a remand. His habeas petition clearly outlines a series of involvement by an American officer in his mistreatment in Rossland. The American agent was present when Mr. Mendez was arrested. He was present when the car in which Mr. Mendez was riding as a passenger was searched. Furthermore, that agent accompanied the Rossland police to the cell in which Mr. Mendez was brutally incarcerated for over a year. And then later, when the Rossland authorities questioned Mr. Mendez, when they denied him food and water, when they threatened him with torture, with people screaming in nearby rooms, an American agent was present. The questioning stopped, they talked to the American agent, they consulted with him, and then they went back to their questioning. Mr. Mendez does not know what the American agent told those foreign officials. He asks only for an evidentiary hearing to prove that the American officials were violating his constitutional rights. The clear remedy for a violation, for a joint participation violation by United States officials is release. When Congress enacted this treaty and its enabling legislation, it talked about joint participation by Drug Enforcement Administration officials. And it explicitly stated in the legislative history that if a prisoner could prove joint participation, a constitutional violation, he could seek and obtain habeas corpus relief. Mr. Mendez only asks what has been granted to him by Congress in this case. In addition to the constitutional violations and the fact that Congress clearly intended to provide a remedy, this court should keep in mind that the Drug Enforcement Administration is a very powerful law enforcement mechanism abroad. It spends millions of dollars, and if this court does not...
What is the remedy for a violation of the Mansfield Amendment in your view?
It is clearly release, Your Honor. Congress, in enacting the Mansfield Amendment...
The statute doesn't say that, of course.
That is true, Your Honor. First of all, when the enabling legislation was enacted, Congress stated that if a prisoner could prove mistreatment by a Drug Enforcement Administration official, which was either unlawful or unconstitutional, he could seek and obtain habeas corpus relief. Secondly, when Congress enacted the Mansfield Amendment, it was concerned specifically about mistreatment of American citizens abroad by Drug Enforcement Administration officials. And it anticipated that that amendment, that the Mansfield Amendment, be used in the context of Americans who would be prosecuted in the United States, who would somehow be thrown into American jails because of mistreatment by American officials. In this case, that statutory violation has been alleged by Mr. Mendez, and it is very clear that he should be allowed to prove that the Drug Enforcement Administration violated the Mansfield Amendment. It is clearly to be used in this type of situation in which a Drug Enforcement Administration official was present at Mr. Mendez's interrogation session, in clear violation of the statute which Congress has outlined here.
Are you arguing then that there's no need for an evidentiary hearing, that therefore there should be an immediate release, that the participation that you are able to allege is enough to require the immediate release?
There is a timing question with respect to the Mansfield Amendment, Your Honor. The Mansfield Amendment originally said that it is a violation of U.S. law to be...
I understand the timing problem, assuming we pass that.
Yes, this court should order Mr. Mendez's release.
And no further evidence need be obtained.
That is true, Your Honor. It is important to recognize that under the law outlined by Congress here, if he obtains habeas corpus relief with respect to Drug Enforcement Administration joint participation, he cannot be sent back to Rossland because, as Justice Gibbons pointed out, the return provision only applies when there is some sort of a violation of the actual procedures involved with the transfer. This court should thus grant Mr. Mendez's habeas corpus petition under the Drug Enforcement Administration allegations. And if it does not grant Mr. Mendez's habeas corpus petition with respect to the Mansfield Amendment, it should remand this case to the district court. Mr. Mendez has suffered much mistreatment at the hands of foreign authorities, but his transfer to this country and his hopes of obtaining judicial relief in this country, both with respect to the transfer and with respect to the mistreatment by Drug Enforcement Administration officials, should be heard by this court. And on remand, the district court will find facts which will lead to Mr. Mendez's relief and will thus mean that the constitutional issues of the treaty need not be reached. Thank you.
Mr. D'Angelo?
Yes. Your Honor, my argument tonight is that Mr. Mendez, my client, is now being held in a United States jail in violation of the Fifth Amendment because his imprisonment is an execution of a foreign conviction that was so fundamentally unfair that it can provide no reasonable person with a basis for belief in his guilt. First, I will address the political question doctrine, and I will argue that the court must not abstain from hearing Mr. Mendez's Fifth Amendment claim because the court is not only competent to hear that claim, but is in fact the only branch of government before which Mr. Mendez can get relief from this constitutional violation. Mr. Mendez's claim is that the executive and the legislative branches in the joint conduct of foreign policy have violated his individual rights to liberty. This court has never before, on political question basis, abstained from an individual's claim that his constitutional rights were being denied. Further, the specific review that Mr. Mendez is asking is a review by a district court on remand in this case of the circumstances involved in the procedures employed in his foreign conviction. While this is not something that district courts are accustomed to performing every day, it is not a procedure or a review which is beyond their competence. The district court upon remand will take the evidence necessary to find the facts and will apply standards of minimum due process which it can draw from its own jurisprudence, which it can draw by application for minimum standards of international law. The same kind of a review of a foreign procedure would occur if a court were being asked to recognize or to give collateral estoppel effect to a foreign judgment in a civil procedure. The standard that Mr. Mendez is asking is that the procedures employed abroad as a totality provided some fundamentally fair opportunity to litigate the guilt question.
Mr. D'Angelo, with respect to the propriety of a court looking into this Rossland conviction, are you making a distinction here between property rights and liberty, and let me put it specifically, in terms of the active state doctrine? Our judiciary will not look into a foreign expropriation on foreign soil, even if it is done without any process, without any compensation, and even if that very property should show up in the United States. We will not look behind that foreign active state. Although it deprives someone of property, we would say without compensation, without due process, unconstitutional under our standards and perhaps international law standards. We will not examine it. Why should we examine this claim, this liberty claim, if we would not examine that property claim?
Yes, Your Honor. The first distinction between the act of state doctrine in this case is that the act of state does not go to justiciability. It becomes a bar to the court's inquiry, as Your Honor said, but the court would take the case. But secondly, and more importantly, in this context, the government of the United States is being asked to actually execute the judgment, so that in the act of state precedent cited by the government, what the court was being asked to do is to recognize the fact that in a foreign nation a confiscation had occurred, and that the new owners, the government, which nationalized the property, now is seeking, in Sabatino, the major case, to get the return, to get the benefits, the proceeds from the sale of that property. And the court would not look behind to try the title, because that title occurred in a foreign nation. What would be involved in this case would be a different analogy, where a foreign nation might come before the federal court and ask that court to actually put a lien on a bank account of a private citizen because the foreign nation abroad had confiscated that property. And the act of state doctrine, I think, does not demand in terms that the United States court becomes the instrument of the actual confiscation itself. Finally, the political question doctrine cannot be a basis for abstention in this case, because this court has held in several occasions that the government, when executing and negotiating a treaty, must abide with the Constitution. To hold otherwise would be to say that the government, in the conduct of its foreign policy, has some extra constitutional powers which it has in no other area of our government. If the court is not competent, if the court is not able to enforce the Constitution in foreign policy issues, that's exactly what would happen. And that's
the Constitution doesn't apply extraterritorially, does it?
Excuse me, Your Honor?
The Constitution doesn't apply extraterritorially.
The Constitution would never apply to foreign officials operating against an American citizen. But what the Constitution in this
What you're
case,
complaining about is the action of foreign officials.
Yes, Your Honor, I agree that the underlying claim is that the foreign officials did not provide Mr. Mendez with a fair procedure, but the Constitution...
What claim does Mr. Mendez have in American law for those fair procedures?
Mr. Mendez has a claim under the Fifth Amendment that he will not be deprived of his liberty by federal officials, specifically the federal prison officials who are now incarcerating him without due process. The due process which he is demanding is that those federal officials assure themselves upon review of the foreign procedure which they are agreeing to execute, that foreign procedure was a fair one and that it provides them with a reasonable basis for belief in Mr. Mendez's guilt. Mr. Mendez is not asking that this court set a precedent which would refuse execution of a sentence of a prisoner who was indicted without a grand jury or not given a Miranda warning or some higher standard applied to our own procedures, but simply that the procedures as a whole employed in Rossland provide a full and fair opportunity to litigate the guilt question. Because of that opportunity were not provided.
So the content of this right that you're asserting is not the technical language of the Constitution.
Yes, Your Honor, because the content of the right is that...
You concede that he couldn't raise a jury trial issue, or do you?
Yes, Your Honor. What
is the content of this right, then? You say minimum fair protection. Right. And where do we find it?
Your Honor, Mr. Mendez is asking that the court apply the due process clause. And in deciding what process is due him, the court must recognize, and the court will recognize, that there are circumstances involved in this treaty which would make it unreasonable and unnecessary to apply the whole array of constitutional protections which have been applied to the state.
Where do we look to find what this minimum is?
Your Honor, the court can look at standards which have been used in the past, many years ago, for instance, the shock the conscience standard.
Pre-incorporation definitions of due process.
Mm-hmm. Pre-incorporation standards, yes, Your Honor, because, again, we're not, and Mr. Mendez does not expect the court to apply the full provisions of the Bill of Rights on, or expect Rossland to comply with them, or any foreign nation to comply with them.
Are there any suggestions of minimum standards in customary international law of human rights?
Yes, Your Honor, we've cited several cases in our brief which indicate that several of the procedures employed in Rossland, for instance, the lengthy incarceration without charges against him, the the being held without being tried without a counsel, and the use of a tortured confession would be violative of international law. The precedent
As found where? As expressed in what?
These were cases which were tried before a commission established to arbitrate claims between the United States and Mexico, both parties having granted sovereignty to that commission to try damage claims against Mexican officials.
Are there any other treaties which contain any such standards?
Your Honor, under the United Nations, various human rights standards have been executed. The problem in this case is that we don't know if Rossland is a party to those treaties, so we can't say that Rossland...
How about the United States?
The United States is a party to those treaties, of course.
Which ones?
Your Honor, because we felt that...
Which ones?
The Vienna Convention of Human Rights, Your Honor, would be one. The review that Mr. Mendez is seeking to perform in this case is the kind, basically, that was established or set out in multiple offender contexts, where, like the United States, New York was imposing a sentence, an additional term of years, on a defendant on the basis of a foreign conviction. And the courts held, in the Second Circuit, that that could not be done if that foreign conviction violated due process.
Well, you certainly don't argue that that was Congress's intention with this treaty, do you? That the courts here make that kind of inquiry?
Your Honor, there's some contradictory indications in the legislative history which might lead the court to hold that there was a caveat in some congressman's mind that the courts might reserve as a matter of constitutional law a case-by-case review for this specific kind of a claim, that is a claim of total lack of fundamental fairness.
Well, the clear provisions of the treaty would appear to negate that kind of an intention, would they not?
Your Honor, the specific language of 3244.1 would appear on its terms to negate that kind of a review. However, it might also be pointed out that the government has never challenged that Congress intended the review of a DEA agent's activities, and 3244.1 in terms might also be interpreted to review that. We're asking the court to go behind the language of the statute and look at the intent and some of the problems that were raised in the lengthy legislative hearings over this constitutionally untried treaty.
What else can that Article 6 of the treaty mean than that the United States should not look into these convictions?
What Congress...
I can understand an argument that says Article 6 is unconstitutional.
Yes,
but I don't understand an argument that says Article 6 permits the United States to review Rossland convictions.
Yes, Your Honor. The way that it might be interpreted to suit our means is that because habeas corpus has been held to go to the question of detention alone, then it would not, in effect, or it would not, in legal terms, go back to the sentence, or rather to the conviction, so that habeas corpus might be a kind of collateral review under the terms of the treaty. But as Your Honor said, if the court will not find that legislative intent in 3244.1, then that statute must be struck down as unconstitutional as applied to Mr. Mendez. Because Mr. Mendez's claim is that he is being denied his basic Fifth Amendment right to liberty. Now, Congress certainly has powers to restrict the jurisdiction of the federal court.
Well, he certainly didn't have that claim as he was sitting in the prison in Rossland, did he?
No, Your Honor. He had no hope of enforcing any right at that point. But the violation of the Fifth Amendment does not occur until he's imprisoned in the United States.
Apart from your claims about the DEA agent, that happened in Rossland.
Yes, Your Honor, but even that claim, while the violation occurred in Rossland, he had no realistic opportunity of enforcing that claim because he was being held incommunicado in a foreign jail. So that he had a right, but he had no means of enforcing that particular right. And as Justice O'Connor points out, he had no right under the Fifth Amendment until the United States acted against him by imprisoning him. Now, Congress's powers under Article 3 to regulate jurisdiction, like all its other powers, must be regulated by the Fifth Amendment. If Congress is so able to use its jurisdictional powers as to deny a prisoner any opportunity to press into...
Why isn't this simply a reasonable qualification on a very substantial benefit? And specifically, can you tell me how this case differs from the case of, I believe it was Mrs. James, who was a recipient of public assistance, a benefit?
Yes, Your Honor, I can.
She had a Fourth Amendment right but she received that benefit, and that meant that she relinquished her Fourth Amendment right to treat her home as her castle, did it not?
Yes, Your Honor, but I think the analysis which was applied in Wyman v. James cannot be applied in this case, because the court begins its analysis in Wyman v. James and in the other unconstitutional conviction cases by looking at exactly what it was that the government was imposing as a condition. And it either considers whether or not that was constitutional in itself, and in Wyman v. James, the fact that the court went to great pains to hold that it was not a search, it was not an investigation for criminal matters. It was concerned with the actual act the government was performing. Then it goes on to decide whether or not it can condition that act on the benefit. In this case, the court doesn't get to that second step because it stopped right at the beginning, because what the government is seeking to do is to imprison people, to punish people in the United States without inquiring into their guilt.
Government is seeking to get people out of foreign prisons, to benefit them.
Your Honor, the terms of the treaty is called a Treaty for Execution of Penal Sentences. The terms of the treaty provide for the execution of penal sentences on offenders. Those are the terms that are used over and over again. The government is imposing a punishment on Mr. Mendez. He faces 7 years in the federal penitentiary or under the restrictions of parole.
Are you seriously contending that the United States negotiated this treaty in order to punish American citizens abroad, rather than to ameliorate their conditions?
Your Honor, the United States negotiated this treaty as the result of public outcry over the conditions of these prisoners, most of whom, and the legislative history reveals it, most of whom were in foreign jails because, in large part, of the DEA and United States government actions. The United States, in presenting this treaty to Congress, indicated that its concerns were rehabilitative, which indicates that it was concerned with punishment as a corrective measure. And the treaty in its terms also talks about offenders. Now, admittedly, it's certainly true that a prisoner in the United States penitentiary is in much better shape than he is in Rossland. But still, he is being punished. He is being treated like every other prisoner. And the constitutional question is whether or not the United States can punish people who are not guilty, who have never been proven guilty, and who have no evidence of guilt lodged against them. Mr. Mendez's specific remedy to habeas corpus is protected by the suspension clause. Now, we're not asking the court to interpret the suspension clause so expansively as to provide guarantees for every kind of claim that Congress or the courts have allowed inmates to bring in the past 200 years. We are asking the court to apply the suspension clause to this unprecedented situation in light of the historical purpose of that clause and in light of the historical function of habeas corpus in our system. And that is to assure that no person is held in the United States jail for a lengthy term of punishment unless that person has 1 day in court in which to present a claim that he or she is innocent. The court should not limit its jurisdiction, should not dismiss Mr. Mendez's claim simply because of his signature on the consent form. The court must consider the coercive conditions under which Mr. Mendez signed that, and even if the court finds that his consent, his agreement to forfeit his Fifth Amendment rights, was voluntary in a legal sense, the court cannot ignore that whatever terms the government offered to him, he would have accepted. And the court must independently put a restraint on what conditions the government can impose. Further, the court...
Should the court ignore what has been argued very strenuously by the government, that if people in this situation, and you have just said that they will consent to anything, are permitted to challenge their incarceration once transferred or released from prison, then the hope of maintaining these treaties, which come up every 3 years for renewal, or to negotiate any more, that hope will be dead. Should the court disregard that argument, and if so, why?
Your Honor, the court cannot forget about the plight of these Americans suffering abroad. Their situation is tragic. It's particularly shocking that the United States is in large part responsible for their suffering, but still, the needs and the demands of those prisoners abroad, however moving, cannot be balanced against Mr. Mendez's absolute right not to be punished on a record which indicates as clearly as it can that he is innocent. Further,
Your answer is yes.
The answer is yes, Your Honor. Mr. Mendez is...
We have an individual case before us, and we can't concern ourselves with the larger purpose of this treaty. That's your answer?
Your Honor, My answer is that Mr. Mendez's claim cannot be overridden by the government's object in executing this treaty. First of all, because a treaty must be constitutional. Secondly, if that were so, if Mr. Mendez's individual right could be balanced against the demands of the many, then the individual right would always fail.
Why isn't your answer that the treaty doesn't provide for return?
Your Honor, that's true, that if Mr. Mendez is released, he would not be returned.
And doesn't the statute even permit the Attorney General to exercise discretion against return?
Yes, that's true, but I think in part the problem that Justice Ginsburg was discussing would be if he were not returned, would not then Rossland refuse to transfer up future prisoners? Now, another response to that question is that we don't know what Rossland will do. We have the government's assertion that it will react negatively, but we don't know whatever motivations led Rossland to enter into this treaty with the United States, with whom it has close cooperative relations, in which we can...
We do know, or I assume we can take note of one reported decision, Rosado, in which one country that had such a treaty threatened to terminate it.
Yes, Your Honor, that's true. Mexico did do that. And even if the court had before it absolutely proven that Rossland would do that, still, the court could not deny Mr. Mendez's claim. We can only hope that the government will seek some other means to help and to give assistance to those prisoners who are abroad. But again, their claims cannot be balanced against Mr. Mendez's. And I think especially in this case where the court is precluded from inquiring into so many of the specifics of the government's assertions, its assertion that this was necessary in the context of the negotiations, the assertion that it was motivated by a humanitarian purpose, the court can inquire into those claims, and therefore the court cannot make an important constitutional decision based only on the unsupported and unprovable allegations that the government makes. The court also must recognize that if it dismisses Mr. Mendez's petition, it and the federal judiciary will be involved in the incarceration of innocent people in our own jail system. And the travesty of justice which will occur will have a corrupting effect on our own judicial system and may in time come to negate whatever humanitarian purpose there was in the treaty. Finally, the court must recognize that the record in this case presents as clearly as it can ever be presented the question of whether or not the United States jails can be used as a place to punish people who have not been proven guilty and whom the government has never attempted to prove guilty. If the court sets that precedent, as the government asks tonight, the government will be free to operate under this treaty and future treaties, imprisoning people no matter how shocking and how unreliable their convictions abroad. But if instead the government grants Mr. Mendez's petition and dismisses him, holding that the United States cannot constitutionally punish someone on the basis of such an unfair foreign conviction, then this court will simply be giving respect to principles of human rights which this nation has long honored at home and long espoused abroad. Thank you.
Mr. Nelson, you've reserved 3 minutes, is it?
Yes, thank you very much. May it please the court, I have just 3 brief points to make in rebuttal. The first goes to the validity of consent question. Respondent has based his arguments here tonight and in his brief that consent is invalid on the lack of a verification of consent hearing. Respondent has never argued with the presumption that the government obeys the law and that therefore the consent hearing can be assumed to have taken place. Nor does he argue tonight that since the record is not silent on voluntariness, he does not have the burden of proof that that verification of consent hearing was not held. What he does argue is that, first of all, no notarization is to be found on the form that a magistrate signed it. But a notarization was omitted. The record is not complete on that point. Just as the record is not complete, for example, with docket numbers on the petitioner's petition, on the Mr. Mendez's petition for habeas corpus, and so forth. He argues also that the transcript of the magistrate's colloquy with Mr. Mendez was not admitted into evidence. But again, the court below specifically said that it was not cataloging all the evidence that was brought out at the consent hearing. This is a joint appendix. If Mr. Mendez did intend to make this argument, and of course he didn't allege it in his petition, he should have made
sure. is inadequate in these respects, wouldn't a remand be appropriate, considering especially the superior availability of information to the United States?
Well, the government is certainly confident that if the case were remanded, it could prove again that the verification of consent hearing was held. But the government also contends that on the face of the record, it is, as a matter of law, the fact that a verification hearing was held because of the points that I've just enumerated. No contrary allegation has been made. The government did say in its answer that the hearing was held. The consent form itself seems to indicate that such a hearing was held. Secondly, on
but the finding that the magistrate is supposed to make under the statute is not in the record.
The result of that, the verification of consent form was filled out and signed, Your Honor, that it was
verification of consent form was filled out, which perhaps
and you're correct. The notarization has been omitted, but it is in the record that
more than a notarization, isn't it?
Excuse me?
Isn't it more than a notarization? Doesn't the statute require a finding by the magistrate?
The statute does require a finding. It doesn't lay out any sort of indication as to how that finding is to be made. Certainly, a notarization could be enough, and I don't know precisely what that term means.
Well, it may mean one thing in Rossland and quite another thing in Massachusetts.
That's correct, Your Honor. The second
But there
point.
is a form that has been in common use, and that was the form that was cited from the Rosado.
That was a form that was in use in Rosado. I don't know whether it was just, we don't know what the form was for Mexico. We do know that a verification of consent form was signed, that it was notarized, and that notarization was then removed from the record. We also know that the form speaks to the presence of a verifying officer. In conclusion, I'd like to ask this court the government would ask this court to overrule the opinion of the appeals court below, not only for the points on validity of consent that I've enumerated, but also because the respondent here tonight has not shown that the benefit that Mr. Mendez gained by transfer could not be burdened by the conditions that the government set out. Thank you.
Thank you, counsel. The matter is submitted, and the court will recess pending its decision. The court has considered the briefs filed by the parties and the arguments, and would like to extend our compliments to counsel for both teams for a fine job in preparing and drafting the briefs and in presenting the oral arguments. As judges all who have sat on many an argument, we were impressed and extend our compliments. For the best briefs, the judges have selected Petitioner's briefs as being the better of the briefs, and we have selected as the attorney giving the best oral argument, Mr. Frederick Nelson. We have selected as the winning team counsel for the petitioners considering both the briefs and the winning oral argument. Congratulations. The court is now at recess, and the judges will be available to speak individually to counsel should they so desire. Thank you.